California law, elder or dependent adult abuse restraining orders. A presentation by Bob Benjy and Benjy Law Corporation. Disclaimers. This presentation is not intended as legal advice and is not intended to establish any attorney-client relationship. Rather, this is merely intended as a general overview of the subject matter, purely for educational purposes. If you believe you may have a claim, you are encouraged to promptly contact a qualified and experienced attorney. Delay may result in a waiver of your rights and remedies. Scope of this presentation. For purposes of brevity, this presentation is intended as a general overview of California law concerning issuance of a restraining order to protect an elder or dependent adult from various forms of abuse. Definition of an elder adult. Any person who is 65 years of age or older that lives in California. Definition of a dependent adult. Anyone between the ages of 18 and 64 living in California and suffering from mental or physical disability, preventing her from doing normal activities or from protecting herself. The type of restraining order we're talking about today would apply either to an elder adult or to a dependent adult. Either one. Types of abuse giving rise to this type of restraining order. Any of the following types of abuse may be grounds for issuance of a restraining order against the at-fault party. Physical harm or threats of violence, neglect, financial abuse, or theft or fraud, abandonment, isolation, abduction, or other behavior causing physical harm or pain or mental suffering. Specific examples of abuse may include threatening to harm the applicant, bullying the applicant, verbally attacking, demeaning, or belittling the applicant, theft or financial fraud, forging the applicant's signature on financial or real estate documents, improper or unauthorized transfers or gifts, violence, including striking or hitting, a caregiver withholding the applicant from things or services necessary to avoid pain or suffering, unauthorized or improper deed transfers. Please click the like and subscribe button for this video. Please click the thumbs up button and the bell icon for this video. This helps the YouTube algorithm provide wider distribution of this video to other folks that may be interested in this subject matter. Thank you. Purpose of a restraining order. A restraining order is an order of the court to the respondent, the aggressor party, which may include orders to leave the applicant alone and not contact her, not approach the applicant or her family members, avoid the applicant's place of work, residence, or other locations the applicant frequents, move out of the applicant's home, and not own a gun. Orders to the respondent for clinical counseling or requiring attendance at anger management courses in those cases where there is physical abuse or deprivation of care. The applicant may request and the court may grant an order requiring the respondent to attend clinical counseling or anger management courses. This, however, is not available if the only form of abuse is financial abuse. Loss of the right to own a gun. In certain cases, particularly where the respondent is found to have been violent or made threats of violence, the applicant may request the court, and the court may grant an order prohibiting the respondent from owning a gun. Right to attorney's fees. Where an applicant successfully prosecutes a restraining order, the applicant may request and the court may grant an award of money damages against the respondent in favor of the applicant in the amount of the applicant's reasonably incurred attorney's fees. Temporary restraining order. When the applicant applies for the restraining order, she may request that the court issue a temporary restraining order, which usually lasts only about 20 to 25 days, to protect the applicant from the respondent pending the trial or hearing on the application. So in the interim period, the temporary restraining order would be there to protect the applicant. TROs are limited in their temporal scope and will self-extinguish unless the court earlier issues a permanent restraining order. Hearing on the restraining order. When an applicant applies for a restraining order, the court will set the matter for a hearing in the coming weeks. The hearing is like an informal mini trial. Cross-examination of the applicant and respondent is allowed, but the rules of evidence are typically relaxed. The applicant will want to take photos, emails, text messages, proof of financial fraud or theft, medical or police reports, etc., to the hearing to help present her case in support of issuance of the restraining order against the respondent. Where the witness statements are going to be relied upon, the applicant should file under oath witness declarations concurrently with the filing of the restraining order paperwork, and then serve all the paperwork, including the witness declarations, on the respondent ahead of the hearing. Outcome of the hearing. Where the applicant prevails at the hearing, the court will issue a permanent restraining order, which takes the place of any TRO that may have been issued earlier at the time of the filing of the original paperwork. The permanent restraining order has an initial term of 5 years and will thereafter expire unless it is subsequently extended before it expires by written request to the court. Once the restraining order is issued, it is entered into a statewide police database and shared with police authorities throughout California. Reminder to like and subscribe. If you got some real value from this video and have not already clicked the like and subscribe buttons for the video, please consider doing it now. We greatly value and appreciate your support, and thank you in advance. What next after winning at the hearing? Where an applicant prevails at the hearing and the court issues the requested restraining order, the applicant should cause a copy of the entered restraining order to be served on the respondent by a third-party process server, perhaps the sheriff or a private process server. Thereafter, the applicant should cause a copy of the proof of service, which is like a receipt, evidencing that service was effectuated upon the respondent, to be filed with the court. Only then can the applicant safely know that a violation of the restraining order by the respondent will have serious consequences for the respondent. What if the respondent violates the restraining order? Any violation of the restraining order, including continuing to contact the applicant after being served with a copy of the entered order, subjects the respondent to risk of arrest, jail, and/or fines. In fact, in such an instance, the applicant could just call the police and say, I have a restraining order against the respondent. The respondent is at my house. He's not supposed to be here. Come and take him away, and they will come and arrest him. Call Benjy Law Corporation for a free consultation. We offer a free 1-hour legal consultation with an experienced attorney. This can be done either in person at our office in Beverly Hills, California, remotely via Zoom or FaceTime, or telephonically. The consultation is free of any obligation and completely confidential and protected from disclosure to third parties by the attorney-client privilege, even if we're not ultimately retained as your legal counsel. To make an appointment, please call us at 310 area code 203-2650 or email us at info@benjylaw.com. That's info@benjy like yellow, law.com. This concludes this video. We hope that you found it informative and useful.